Good morning, Judge.
Good morning. Good morning. This is Judge Alyssa Perez presiding over the 210th District Court Civil Docket for March 26, 2025. All matters being heard today are being heard in accordance with all directives regarding.
Good morning, Judge.
Good morning. Good morning. This is Judge Alyssa Perez presiding over the. Somebody needs to mute. Is that you? Docket for March 26, 2025. All matters being heard today are being heard in accordance with all. I certainly don't need to hear myself twice. Somebody needs to be.
Yes, ma'am.
If you click on the video, I certainly don't need to hear. If not, I'll mute you. We'll do it like that. All right. Let's see. Let me let Mr. Gonzalez in. All right, but then that means I also organize the docket. Are you good, Mr. Nanez? Can I unmute you now? Yes.
Yes, ma'am. I'm okay. I apologize for that, Judge.
No worries. It happens. If you would please, where are we headed? Where's our first case?
Page 1, Judge.
Mhm.
Calling cause number 2023 DCV 1997 Edna Torres et al. Versus Narda A. Galza. Announcements, please.
Good morning, Your Honor. Thomas Carter for the plaintiffs.
Good morning.
Good morning, Your Honor. Gabriela Trujillo for defendant Narda Carrion.
All righty. This final civil pretrial. How are we doing on this one? God, the system is really slow today. God,
Yeah, Judge, we've been in conference. I was speaking with defense counsel earlier this morning. We've kind of got a situation here, at least on the plaintiff side, where this is a very, very low impact case. And the way that it's developing, there's a chance that, or a large chance that the plaintiff wouldn't recover anything in this case, just due to, the low impact and everything else that's involved without going into too much detail. And so I was in conversation with the defense about it, and we may be able to come to an offer. I need to talk with my client and kind of go over all this stuff with her again. That's kind of where we are right now, Judge.
did you ever, I see defendant filed their proposed charge, witness list. We have our trial in April. Yesterday would have been your mediation deadline. I'm going to assume that didn't happen since we're just kind of formally talking.
We did. We already mediated this
Oh.
case before with Judge Speasney, and it didn't go anywhere. It didn't go anywhere. This is just kind of one of those cases, Judge. So we have made efforts on both sides. This may be one of those where we, may have to come to a settlement, or I may be filing a motion to withdraw after speaking to my client. But we're not ready for trial on this case, Judge.
Mr. Carter, are you asking for a continuance, or do you want me to leave that docket call date and trial set?
I'd like to, we can file a motion to continue, but I'd like to let the court know that, yes, we would like that.
Ms. Trujillo, I see you all filed some things, so what is your position?
Yes, Your Honor, I filed my my pretrial docs. I've been in contact with the adjuster. I think that we can get something squared away before our April trial date, but if we do get a continuance on file, I'll agree to it.
Okay, let's leave that outstanding. I'm going to leave your dates. Mr. Carter,
okay, that works.
You and Ms. Trujillo don't think it's going to be disposed of by that April 23rd docket call, then please submit, if it's agreed, an agreed motion for continuance, and we'll just get you reset. Please include in there if you are requesting another trial setting, or if you are requesting, 60 days final civil or something like that, okay?
Okay,
Yes.
okay.
Thank you. If you don't have anything
Ms. Trujillo, thank you.
You all are excused, okay?
Thank you,
Okay,
Judge.
thanks,
I'll
y'all.
follow up with you, Ms. Trujillo.
Thanks, guys.
Bye-bye.
Sounds good. Bye.
Bye-bye.
Who's next, Mr. Nanez?
On page 2, Judge, that was all for page 1. Everything else on page 1 has been reset, Judge. So moving on to page 2, calling cause number 2023 DCV 0040 Jasmine Silva individually et al. Versus Albino Rangel Ramirez et al. Announcements, please.
Stephen Lucy on behalf of the plaintiffs, we're ready to proceed.
Good morning, Your Honor. Rebecca Alvarez on behalf of Early Trucking and Mr. Albino Rangel.
All right. Final status conference, and we have a June trial date. How are we doing on this one?
Your Honor, we are going to be filing a joint motion for continuance as one of the plaintiffs is still treating. We've completed treatment for one of them, but the other party, particularly Pedro, is still treating, and we need to set up a mediation. The earliest availability for the agreed mediator between the parties is July, and we are currently scheduling
that?
depositions. It's going to be let me
Mitch
see.
Moss, Your Honor.
Mitch Moss, yeah, yes.
All right. So with that July mediation, I mean, are you all wanting, so you're in agreement, Ms. Alvarez?
Yes, Your Honor, we're in agreement. I think at this stage, if plaintiff is still treating, we'd like to give them a little more time to get a better idea of what those damages look like so we can make mediation productive.
Okay. All right, then when I see the motion, just keep those key dates in there. We'll sign off on it to get the trial rescheduled because that doesn't even fit within our trial schedule, right? The mediation.
Correct.
But the sooner we get things scheduled, even if we're going past this trial date, the sooner you will have your trial. So if for example, you send me a joint motion right now, and if you can give me a date, you know the exact date when you're mediating?
No, Your Honor.
Mm,
We're discussing that with opposing counsel.
okay, so we don't have a firm date in July. So, yeah, send me your motion. I can tell you this, I'm going to, with this continuance, issue an order to get the mediation scheduled within, you know, like end of August. Okay, because we're resetting. I understand that the mediator schedules sometimes are very difficult to accommodate if you don't hit them early. So, but I don't want to push that mediation back until another final civil pretrial in 2026, because likely you're looking at a trial setting in 2026. Okay.
Thank you, Your Honor. Understood.
Thank you very
Thank you,
much.
Your Honor.
Send me the motion. Do you have anything else?
I believe that's all I have, Your Honor.
Okay.
Nothing
right.
further from us, Your Honor. Thank you.
Thank you. You both are excused. Have a good day.
Thank you, you too, Your Honor.
Judge.
Okay, who's next?
On page 2, Judge, calling cause number 2024 DCV 2370, Joshua Lintz versus the University of Texas at El Paso. Announcements, please.
Aaron Martinez for the plaintiff.
William Farrell for the defendant.
All right, final civil pretrial as well. Ms. Martinez, how are we doing?
Well, Your Honor, we had filed a joint motion to continue because the last deposition, there was some new information that came out, and so we need to take another deposition in this case. And so we were waiting on the court to see if the court made a ruling on that motion to continue.
I don't have, and Myrna, if you'll double check me, I just checked my emails because I see the agreed motion filed on March 7th. It's in the court file. I don't know that we received it. I don't see it in my emails. Obviously, if you all have agreed, that's fine. Send me the order. I'll sign off on it. What I will ask then is, Myrna, if we could have a new trial date, again, likely in 2026, and then we'll get you all to redo your scheduling order and send it back to us, okay?
Yes, Your Honor. Thank you.
Let me see, Mr. Farrell, I'm sorry, I lost you in all the boxes there. I see you now. Any issues with that?
No, ma'am.
Okay, all right. Myrna, did you receive the motion for continuance? And you're muted?
I'm checking my emails, Judge.
Oh, here's the proposed order. If you will pull it from Odyssey, Myrna, I've been trying to print things from Odyssey and I'm still waiting on about three documents that are printing like one page every 5 minutes. So
I'll send it over.
thank you. All right. Anticipate when I receive that, we get the scheduling order, obviously cancel the May dates, okay?
Yes, Your Honor. Thank you. We appreciate it.
Thank you for your time.
Thank you, Judge.
All right, who's next?
Judge, page 2, calling cause number 2023 DCV 1115 Del Bravo Inmuebles et al. Versus Amglo Chemlite Laboratories, Inc.
Your Honor, good morning. Hugo Maldith here for the plaintiff, I'm sorry.
Your Honor, Payne Kynarth and Heather Kramer for the defendant.
Good morning. Good morning, council. I have us down today for a scheduling status conference. And we have a temporary injunction hearing, is that correct? In May.
That's,
But we don't have a trial date, and that's what we're here to talk about. Have you all discussed a timetable?
Judge, we have not. You may recall we had a previous trial setting when Mr. Walker was involved, and then we got a brief continuance or a continuance, Your Honor.
Mhm.
But, you know, I'm not sure how the court is looking the fall, maybe early, late fall. Obviously, I haven't talked to opposing counsel, but subject to their, you know, their availability, Your Honor.
Just so you all know, I feel comfortable saying that it's going to be early 2026. So Ms. Hernandez can give us a secure date, and then we'll go from there. Any issues with that?
Your Honor, the only thing that we'd add, and I'm kind of filling in for Mr. Walker after he retired earlier this year, but where I understand things were when the trial was continued late last year is that we had a pending motion to stay or abate that was on file, and I don't believe that was ruled on one way or the other because the continuance is granted so the parties could attempt to confer. Our position is still that this case should be stayed because of the concurrent litigation going on in Mexico that kind of addresses all of the issues here. And so we ask that the case be stayed rather than reset for trial. But I understand this is a status conference, and other than to say that we believe that the case should be stayed and we may have a hearing on that issue sooner than later. I don't believe we have an issue with the trial date at some point next year.
And Your Honor, I don't think the court ever held a hearing. Okay, just want to make sure. I believe, Your Honor, no, the court never held a hearing on this issue.
I was, while you were speaking, Mr. Kennarth, I was double checking because I feel like I was aware of the issue, but I could not recall a hearing. And so that's what I was looking up. So, and I don't see.
Right, and I will chime in because I know Mr. Kennarth is new to the case, but I do agree with Mr. Madrid in that no hearing was ever held because the parties did agree to continue the trial date.
Okay, so what that sounds like then is that we have that outstanding motion, Mr. Kennarth, if you want to contact Mr. Hernandez to get that scheduled, if you're requesting a hearing. Normally we do that with an emailed motion and the request to Mr. Hernandez, and we'll get you scheduled. As I mentioned, the injunction, there's an injunction hearing on May 7th. I'm just looking at settings. I'm not getting into too many details. And then with that, I mean, we can still do the scheduling. So we'll get our scheduling order squared away.
Your Honor, was the court coordinator going to send us proposed dates for
I'm going
trial
to ask right now and see if Mr. Hernandez, she might be on the phone. Let's see if we have a date, Myrna.
Judge, February 20th,
Okay,
2026.
thank you.
That works for plaintiff, Your Honor.
Is there anything else outstanding that needs to be heard?
Not to my knowledge, Your Honor. I think that's the application and if the motion to abate is scheduled, Your Honor. I think those would be the only two outstanding motions.
Okay,
Perfect.
so
Thank you.
then once we get the scheduling order entered, anything outside of those dates, please request your hearing, okay? So we don't lose track of things. Okay, anything else?
No, Your Honor, not for plaintiff.
All right, Mr. Kennard, Ms. Kramer? No, all right. Thank you for appearing. We'll see you next time.
Thank you, Your Honor.
Have a good day.
Thank you.
All right, who's next?
Judge, page 2, calling cause number 2024 DCV 1423 Wells Fargo Bank NA versus Isaac Dominguez. Announcements, please.
Courtney Anderson Broadhead here as appearance counsel for the plaintiff.
And Mr. Dominguez, is there anyone, is Mr. Dominguez in the waiting room or has he appeared here at the courthouse?
No, ma'am.
Okay, we are set for our default. I believe this looks like we were reset from March 12th. Ma'am, you may proceed on your motion.
Yes, Your Honor, this is a breach of contract case. The plaintiff was served with their citation of the original petition on or about July 6, 2024. There has been no answer filed in this case. We've expired the time to wait for an answer. The law firm of record has informed my office that they filed with the court a certificate of last name and address, military service affidavit, that they have filed supporting business records, establishing the contract, when the contract started, when the last payment was received, and they assert that they are due damages in the amount, let's see, this is Wells Fargo card number 4309. Let's see. Scrolling through what the plaintiff has filed, $7,995.97, the plaintiff law firm of record asserts, is the amount of money due in damages based on the breach of contract. I ask the court to take judicial notice of the contents of the case file. The plaintiff law firm of record has also asked for attorney's fees. They've asked for $800, I believe supported by an attorney fee affidavit, and then they've asked for future attorney fees of $3,000 if it's appealed to the Court of Appeals, and $3,000 if it's appealed to the Texas Supreme Court. All in, they've also asked for court costs, which I do not have a delineation of the court costs, the filing fee, and the service fees. And I do not see a request for post-judgment interest, Your Honor.
Anything else?
No, Your Honor.
So the court will take judicial notice of all the documents in the district clerk's file on this case, as well as all of the attachments to include the affidavits, declarations regarding attorney's fees, and the military status. What I'm looking for here, though, is I think I do have it. Nope, that's not it. Is the proposed order. So if you could please, if you haven't already sent it to the court, please do so. Makes it a lot easier to find. I'll sign off on it. Judgment is granted and amounts requested, okay?
Yes, Your Honor.
Thank you for your time.
Thank you. May I be excused?
You may. Have a good day.
Thank you.
Next one, Mr. Nunez.
On page 3, Judge, calling cause number 2024 DCV 1090, Clear Channel Outdoor LLC versus GR Express Inc. Announcements, please.
Good morning, Your Honor. This is Erica Stickney on behalf of the plaintiff, Clear Channel Outdoor Inc.
Good morning. Bear with me 1 second. For some reason, everything is super slow this morning. Okay, we're here on is it a default? Yes?
Yes, Your Honor. It's a motion for default judgment.
That was filed January 22nd. Bear with me. Oh. Notice was sent out in February, so about a month ago. All right, Miss, is it Stickney?
Yes.
You may-
Like a stick and a knee. Yeah.
Gotcha.
You ready for me to go ahead?
Yeah. Mm-hmm.
Okay. The petition was filed on this one on March 7th, 2024. It's a breach of contract claim. We served the corporate defendant or the only defendant on November 8th, 2024 by serving the Secretary of State, and that return was filed on November 14th. The Whitney certificate is attached to the motion for default judgment showing forwarding on November 22nd, 2024. We're seeking a judgment in the amount of $14,686.10, as well as 12% prejudgment and post-judgment interest at the contract rate. and attorney fees in the amount of $1,680. And I would ask that the court take judicial notice of the file.
The court will take judicial notice of all documents in the district clerk's file, as well as all the attachments to your motion. Anything else, ma'am?
No, that's all, Your Honor.
Okay, I haven't double checked, but if you would, judgment is granted in the amounts requested. Please send over the drafted order, the proposed order.
Okay, all right.
Thank you very much. Have a good day.
May I be excused?
You may have a good day. Who's next, Mr. Nunez?
Page 3, Judge. Calling cause number 2023 DCV 1705, Elliot Berg versus Alex Zamora et al. Announcements, please.
Casey Stevenson for the plaintiff Elliot Berg.
Daniel Gonzalez for defendant Alex Zamora.
All right, final status conference, is that right? Why do I feel like something has been happening in this case? How about
Yes,
an update?
Yes, Your Honor. So I was recently appointed as counsel for a defendant, I believe a day before the prior status conference.
Right.
Since then, I've gotten up to speed on the case. We're simply just needing to go into settlement negotiations. I have everything that we need, all the evidence collected on our end. We're set for, I mean, I'm ready for a trial date if the court would like to set one. The only conflict I have is May 19th. But otherwise, I don't think there's anything pending other than a response for summary judgment or the summary judgment hearing, which is on the
23rd.
23rd of April.
On the 23rd.
Mhm. So let's see. Okay, yes, I am remembering. And hold on a second. So I have a motion, then we had our summary judgment that was granted. Do we have a response though?
There's
No,
no response to the motion for summary judgment yet, Your Honor.
Okay, am I gonna have a response?
Yes, the hearing's on the 23rd. We'll have a response filed soon.
I don't remember. Did I set a deadline at the last hearing by which to file a response?
I believe you did, but honestly, Judge, I don't remember when it was. And if
Me either.
we'll do whatever we need to do. I think it was 14 days from the date of the hearing.
Yeah, I think it was something like that too. Now, let me just say, Mr. Gonzalez, you know, that's why I like to have these on YouTube because then I can just go back and see what the heck I said if I don't take notes. You know, I think the closer you get to the hearing date, the chance that, you know, I'm going to allow Mr. Stevenson, if he needs more time, to have more time because he received your response so late. Just know that the hearing is set. If you all are asking for a scheduling order, are you asking for that? Or do you want to wait until we have our summary judgment hearing? And then are we asking for a bench trial? Is that what
whatever makes sense to you, Judge, on that end. I mean, once we hear the summary judgment, we'll either win and it'll be done, or we won't. And I haven't done any discovery because I've had this summary judgment out there pending for forever. And of course, there was no response from anybody. And then finally, the other attorney withdrew. And so,
yeah, I also have a notation here that I was going to hear it via submission. So
I'm fine with that, Your Honor. I don't have.
Mr. Gonzalez, I don't know. You know, sooner you get me your response, the sooner I'll look at it. That's all I'm saying.
Yes, Your Honor. We'll have it likely filed by next week. I guess before the due date.
All right, just letting you know. All right, I'm going to leave it as is for now. We'll see you on the 23rd unless you have something else for me.
That's it, Your Honor. Appreciate your time.
Thank you for your time as well. Take care. Thank you, Mr.
Thank you,
Gonzalez. All right.
Judge, let me bring in Ms. Juarez, I guess the plaintiff in the next case. And Ms. Gonzalez, are you the interpreter for this case? You're muted, ma'am.
And this is what I haven't been able to print. Myrna, will you go into this case 3531 and print for me the motion and the response? I think I've only gotten 2 pages. And I just do better with paper.
I'm the same, Judge.
So bear with.
And yes, Maria Eugenia Gonzalez is here for 3531. Interpreter.
Yes, ma'am.
Thank you.
Hello, Ms. Juarez, can you unmute?
Señora Juárez, ¿puede abrir el micrófono?
Okay, I was just gonna ask you if it was for her. Sí, es para usted el intérprete. Okay, necesita abrir su micrófono y ahorita cuando ah, ponga la aplicación del intérprete, necesita primar donde dice español para usted, ¿ok? Pero no, ahorita cuando vuelva la juez y abra la aplicación, va a ver donde dice que va a decir que oprime para uno el lenguaje y oprima español, ¿ok?
And the interpreter doesn't need to be switching, right?
No, ma'am, but
Okay,
she,
thank you.
but I will need Ms. Juarez to select her language, Spanish for her. And then everyone else will need to select English for themselves.
So what's the name of the person who needs interpretation?
Ms. Juarez right here,
Okay,
I
all
believe
right,
it's
I see her.
Mr. Quinones, you did hire for Ms. Juarez, right?
Yes.
Okay.
Nope. Hire, I don't know if I hired, but I requested somebody. Yes.
Hello, Mireya? Hello, Mireya? Hello?
Hi, can you hear me?
Yes, ma'am. What
I'm
case are
sorry,
you
I
here for?
wasn't ready for this.
I'm sorry, what case are you here for?
No, I'm so sorry. It's because I was trying. I'm gonna help Mario Batteries for his hearing with to log in into Zoom. So I was just trying to see if everything is going to work out. That's why I'm right now.
What case, are you involved in the case, ma'am?
I'm not. I'm just helping him with technical assistance
For whom?
for Mario Batres.
I don't,
He has his hearing until 1:30.
until 1:30. Okay, ma'am, you need to come back at that time or speak to
Yeah.
him there, okay?
Thank you so much. I'm so sorry.
Yes, ma'am.
Okay, so it's not just me, it's the system. Maybe it's the way, Mr. Nunez, to keep us from blowing our paper budget that we don't have anymore. They're not letting us print anymore. Myrna's having the same problem. But I do have the summary judgment, and I know, Mr. Quinones, your response is a little bit shorter. So if I don't print that one, at least I have one on paper. Okay, then.
Sorry, just to clarify, do you have my exhibits, or you just don't have them printed, or you do have them?
I have your exhibits.
Okay.
I think I have them all. Come on in.
I'm going to reference them, but if, again,
Yeah, I have them. Thank you, Myrna. Okay. All right, let's get going. Do we need to set up the interpreter right now?
Yes, ma'am.
Okay, let's do that.
Okay. Everyone needs to select the language right now. Señor Juárez, oprima español cuando salga ahorita.
Yeah, and attorneys, if you will select English, because otherwise I won't hear you. Are we ready?
I believe we are.
I can't hear you,
Defense is ready,
Mr.
Judge.
Nunez. You have to pick English.
Can you hear me, Judge?
Hmm?
Can you hear me?
I can hear you, Mr.
Okay.
Quinones.
Yes, we're ready, Judge.
Mr. Nunez?
Yes, ma'am.
Now I can hear you. All right, so I'll call it. Calling cause number 2023 DCV 3531, Petra Juarez versus MGAP LLC et al. May I have announcements, please?
Cliff Jessup here for defendant MGAP LLC, doing business as Four Seasons Pool Service, Judge.
Your Honor, Carlos Quiñones on behalf of Ms. Petra Juarez, plaintiff, we're ready.
And we are set this morning on a motion on MGAP's motion for summary judgment. Mr. Jessup, you may proceed.
Thank you, Judge. We filed a motion for summary judgment on this case based on plaintiff's allegation of negligent entrustment and respondeat superior. The facts of this case, Judge, are simple. On September 29th, 2023, plaintiff Petra Juarez was involved in a motor vehicle accident with Richard Reinhardt. who at the time was driving a 2004 Nissan Titan. Plaintiff has alleged that MGAP LLC owned the Titan that Reinhardt was driving, and that he was acting in the course and scope of his employment at the time of the accident. The summary judgment evidence shows that Four Seasons sold the Titan to Reinhardt in December of 2021, nearly 2 years before this accident. The bill of sale, the final payroll deduction with the payment for the remainder of the truck, and the insurance cancellation notice are all exhibits to our motion for summary judgment in the record as exhibits C, D, and E. Reinhardt's employment was terminated February 10th, 2022, and there's been no evidence presented that he performed any work or services for Four Seasons after that date. With regards to negligent entrustment, ownership at the time of the accident, Judge, ownership and control were fully transferred to Mr. Reinhardt. My client sold the Titan to Reinhardt in December of 2021. The bill of sale and the pay stub showing the final payment and the insurance cancellation evidence all conclusively show that Four Seasons relinquished all interest in that Nissan 2 years before the accident at issue. Plaintiff in his response misstates the law. Title alone is not dispositive. In fact, lots of Texas courts have held that possession and control outweigh title for negligent entrustment liability. In our petition or in our motion, Judge, we've cited the Jacobini versus Hall, the Blanc versus Jensen cases. At the time of the accident, Reinhardt had full possession and control, and he had no oversight over that vehicle by my client, Four Seasons. We've also cited the Hudson Buick versus Gooch case, which again establishes that those are necessary in order to establish negligent entrustment, which are lacking here, Judge. Entrustment was not possible. You cannot entrust a vehicle you no longer own control. The undisputed summary judgment evidence negates the first elements of plaintiff's negligent entrustment claim. With regards to the respondent superior claim, Mr. Reinhardt's employment ended February of 2022. We've submitted a sworn testimony from our defendant owner, Michael Gorges. The sworn affidavit by Mr. Gorges shows that Reinhardt was terminated over 18 months before the accident. There's no evidence presented at all of any ongoing agency. Plaintiff, who has the burden, has produced no evidence which would contradict Mr. George's sworn testimony. There's no payroll, 1099 service logs, or any correspondence that show any work done by Reinhardt after February of 2022, at or near the time of the accident. Plaintiff's response raises speculation. He speculates that there's speculated questions in plaintiff's response. Speculation is not a fact issue. Mere past employment or vehicle association is not enough to raise a genuine issue of material fact. The law requires specific agency evidence or benefit to the employer, and plaintiff has offered none in this case. Texas Supreme Court established this principle, and we've cited 2 Texas Supreme Court cases, Van Horn versus Chambers back in 1998, and it was reaffirmed by the Texas Supreme Court in Maynard Foods versus Goodman in 2002. Again, Judge, plaintiff references the vehicle registration. That's irrelevant, Judge. The fact that Reinhardt may not have registered the vehicle in his name is not probative of control. Four Seasons has no legal or practical control over the Titan after 2021. Anybody who sold a vehicle knows that once you transfer the vehicle to the other person, execute the bill of sale, you cannot control whether or not they register it, keep it registered, inspected, maintained, anything. It's theirs to control from that point on. Plaintiffs also raised that additional discovery requests are necessary. Judge, additional discovery is not evidence. Plaintiff can't avoid summary judgment by saying we need more discovery. There's been no evidence that's presented to raise any genuine issue of material fact. There is no tribal fact in this case, Judge. Plaintiff's had ample time. He's produced no affidavit, no deposition testimony, no documents to contradict our summary judgment evidence with regards to the ownership and the lack of employment of Reinhardt on the date of this accident, Judge. For these reasons, Your Honor, we believe the summary judgment is undisputed and conclusive. There is no genuine issue of material fact that exists as to defendant MGAP. Accordingly, Your Honor, we believe that Four Seasons MGAP is entitled to summary judgment as a matter of law, Judge.
All right, Mr. Quinones.
Yes, Your Honor. As stated in our response, Your Honor, the issue as to Well, as stated in the response, quite clearly, and the most evident is our affidavit by Ms. Juarez. It clearly states that she was in an accident with somebody that had a uniform that said Four Seasons on it. I think at a minimum, that is a fact issue as to whether or not the Four Seasons was the the employer. Excuse me. Also, the fact that there's title to the vehicle registered still under Four Seasons Pool Service. I think that's enough there to move beyond summary judgment at this point, and show to the jury or the factoire that there is a significant issue regarding that material fact as to whether there is apparent authority by Four Seasons. As stated in the affidavit, Judge, and my client's here to validate that affidavit, is that he got out of the vehicle. He was wearing his work uniform that specifically stated Four Seasons Pool Service. He had pool service in the back of his truck, and he also commented that his boss was going to be mad. It's insinuating that he had a boss, that he's not independent, that he worked for Four Seasons Pool Service, and therefore Four Seasons is at least a fact issue to be raised that Four Seasons Pool Service is responsible for the accident respondent superiority. Thank you.
What's your response to that, Mr. Jessup?
Your Honor, that we don't know what he did with that vehicle after it was sold to him, Judge. We do know that his last date of employment with our company was February 2022, Judge. There's a sworn affidavit from my client, the president, Judge. There was no ownership payments, anything like that made to him afterwards, Judge. Whether he was engaged with a different employer or a different pool service, Judge, I think that might be decent questions for Mr. Reinhardt. I don't think they create a fact issue with regards to MGA Pool. Judge, I think the summary judgment evidence presented establishes conclusively that they sold the truck to him, and that's in his pay stub. It shows that. There's also a bill of sale in there. It also establishes that he was no longer employed with the company at least a little more than a year before this accident, Judge. With regards to what Mr. Reinhardt may or may not testify to, Your Honor, her affidavit with regards to the uniform, Judge, is something she observed. With regards to the statements she heard, we would argue that would be hearsay, Your Honor, and since he's been served and not answered, Judge, I don't think that would be sufficient to support to overcome our motion for summary judgment, Judge.
All right. Do you all have anything else?
No, Your Honor.
No? Okay. All righty. I do want to review the attachments here quickly, and so I'll have a ruling for you by the end of the day. Okay?
Thank you, Judge.
Thank you very much.
Thank
Thank
you,
you, Ms. Juarez, and thank you, Ms. Gonzalez.
Thank you all.
And if we can turn off the interpreter function. As far as I am concerned, yes, ma'am. Thank you for your time.
Thank you.
All right. What time is it? Oh, we're right on time. Oh, this is great. Mr. Nikki, you're here on 3694. Mr. Miranda. Okay, let me scoot over to your case.
Good morning, Your Honor.
Good morning. Okay, if you all are ready, yes?
Yes, ma'am.
Yes, Your Honor. Thank you. Calling cause number 2024 DCB 3694, Edgardo Jimenez versus ASRC LLC, DBA All-Star Construction and Roofing. May I have announcements, please?
Stephen H. Nicky on behalf of the plaintiff, Mr. Jimenez.
Your Honor, Carlos Miranda on behalf of the defendant, ASRC LLC, DBA All-Star Roofing and Construction.
Okay, and we have plaintiff's verified motion to remove invalid lien and original petition. The motion to remove the lien, Mr. Nicky, you may proceed.
Thank you, Your Honor. This is a motion to remove an invalid lien pursuant to Texas Property Code Section 53.160. Basically, how this case arose, Your Honor, is the plaintiff met the defendant regarding some hail damage to his roof. The plaintiff and Mr. Jimenez signed a contract to do re-roofing work. Mrs. Jimenez did not sign the contract. The defendant went to plaintiff's home. The contract was signed on February 28th of 2024. The next day, the defendant went to plaintiff's home and demanded money for the roof. At that time, my client canceled the contract with the defendant. The defendant then started sending demand letters. A copy of one is A2 to the affidavit of my client. Then an affidavit of lien, says constitutional lien, was filed on his homestead on March 21st of 2024. The defendant attached a notice of filing lien of constitutional lien. However, that notice was not sent by certified mail, which is required under the Texas Property Code. There's a lot of requirements to perfect a lien on a homestead in Texas, Your Honor. And the defendant pretty much failed on all points that you need to do to perfect a lien on the homestead. Even though it's called a constitutional lien, which is a separate lien based on the Constitution, you still have to comply with the Texas Property Code in perfecting a lien on a homestead. So basically, the first element would be that both the husband and wife have to sign the contract. The wife didn't sign the contract. Prior to any work or materials being purchased, the contract must be filed with the county clerk's office. That was not done either. And also, a very important point is that labor or materials must be provided to the project. In this case, they're not claiming a constitutional lien for any labor or materials. They're claiming that a cancellation fee is what they're asking for. Even in the first paragraph of his notice of lien, it says claimant has an unpaid amount of $3,830 for the contract cancellation fee for the construction and improvements on the property. So there was absolutely no materials purchased, no labor done. So that's another defect in perfecting a lien on a homestead. In addition, Your Honor, Texas law requires two different notices that have to be attached to the contract. Both of those notices are one under 41.007 and 53.254 is the statutory language. It's basically a warning about, signing a contract, for your home and that a lien could be filed. Neither of those warnings were attached to the contract. So basically, there's 7 things you need to do and you didn't do any of them to perfect the lien. The lien is invalid. My client has filed an affidavit stating all these facts. I just sent down, Your Honor, my client was trying to sell his home. This lien prevented him from selling the home. So we had to bond around the lien, which cost my client like over $7,000. They should have sent you a copy of that, Your Honor. If not, I can share my screen and show you.
Give me 1 second.
And if I can do this correctly, I'm not very good at this.
Are you screen sharing?
Yeah.
I'd
rather be there in person.
I think if you were born before 1970, we are unable to screen share.
I think you're correct, Mr. Miranda.
Yeah, I don't see it. Just a quick search in my email, so feel free to share.
Okay, let me see. Let's see if that does it. Does it come up, Judge?
I'm not seeing it. And unfortunately, there we go.
Okay, okay. So this is the bond that my client had to do. It was recorded. You can see the document number and was filed, let's see, on July 2nd, 2024. So the bond that he had to pay was $7,660. We're requesting the cost of the bond. We want to get our money back. That's been filed with the registry of the court, the bond. So we would like a release of bond. I don't know how to turn this off. Let's see. There we go. And then I also had attorney's fees, Your Honor. Those should have been submitted to the court. Unfortunately, a lot of my staff have the flu, so that might not have got to you either. But an affidavit of attorney's fees was filed, which came to $8,472. I was trying to work with the defendant. I worked with Mr. Miranda trying to get the bond released. The defendant unfortunately refused to do so, so we had to file suit. So it should be Exhibit B that was sent to you, Judge, and filed. They may not have accepted it yet. I'm not sure. I'm happy to share screen again and show those.
The only exhibits I see are the ones that are attached to the petition as A and A1.
Okay.
I'll defer to Ms. Hernandez to see if she's received anything, but I haven't received anything.
Okay. I think they were also sent to her email as well. And we would like both of those exhibits admitted once they make it to you as proof of attorney's fees. I can testify live right now if you like for attorney's fees.
Has
And
Mr. Miranda seen any of this? Mr. Miranda, did you receive any of this?
No, Your Honor. I can sympathize with Mr. Nikki as far as staff being out, but I have not, I've only seen what's attached to the motion. I haven't seen the bond and I haven't seen attorney's fees. And just to bring the court up to speed, I did convince my client to release the lien. It's being electronically filed today. I know that doesn't resolve the issue of the attorney's fees and the bond, any additional liquidated damages. I'd like to see the exhibits, review them. I would have no objection to an order being entertained for your purposes to release the lien. It's being released, but I would like to abate the issue of the attorney's fees and the bond till I have an opportunity to review and discuss with my client.
I'm probably going to tend to agree just because we don't have some of these documents, Mr. Nikki, but I will continue to hear your argument right now. What I think I'm going to do is continue this for about 3 weeks. But let's finish what we're doing, what we can do right now. Okay?
Sure, that's fine, Your Honor, and I apologize for them. I just emailed those documents to Mr. Miranda because he said he didn't get a copy. So he should have that in his inbox as well. And I don't know if Ms. Hernandez received those documents from my paralegal.
Hold on, Mr. Nikki. I think I just got an email here.
I did, Mr. Nikki, and I've just sent them to the judge. There's 2 emails, Judge.
Got it. Thank you. Okay, go ahead, Mr. Nikki.
So basically, Judge, we're here today asking that the lien be released, and then I guess Mr. Miranda is taking care of that. So we would still like an order that the lien be released. We do want to be reimbursed for attorney's fees. You know, we've been trying to get this lien released for over a year, and to have it released the day of the hearing, my clients incurred attorney's fees of $8,472. We would request reimbursement. My attorney's fee statements are attached to my affidavit supporting those fees. The bond, we're just asking for the court to release the bond with an order. I'm not asking Mr. Miranda's client to pay that $7,000 or whatever it was, a little bit over $7,000. We just need it released so I can get those funds back from the bond company, and that will take care of that issue. So really the only remaining issue, if you're in agreement to release the bond in an order, is the attorney's fees.
Anything, Mr. Miranda, with respect, do you have anything on the releasing of the bond? Do you have any input?
No objection to that. I'm happy with an order providing for exactly what Mr. Nikki is requesting, and then we just reset for 3 weeks on the attorney's fees, and perhaps we can work it out in the interim too.
Correct. And I say 3 weeks, it might be 4 weeks, just because we have some things backing up. I
That's
feel
fine.
like 3 weeks is gonna mean,
21 days exactly, yes, Your Honor.
is gonna mean, I don't know if that is Holy Week, right? It might be
It's
20.
mañana. We'll reset it for mañana.
So here's where I am today hearing it, and I think I've heard what I need to hear from Mr. Miranda, that he can respond right now, is this. If you will send me some type of agreed or signed off, approved as to form order with respect to the lien, and then with respect to the bond, I don't necessarily need Mr. Miranda's signature on that one, but I would like it on the first order. And then we are going to continue this hearing with respect to the attorney's fees.
Yes, ma'am.
I'll have that set for hearing. You send me the other orders, I'll sign off on those as soon as I get them.
Yes, ma'am.
And once you've circulated everything, please make sure you circulate everything you need for the follow-up hearing, okay?
I will do that, and I'll send the proposed order to Mr. Miranda for his review and signature.
Thank you very much, Mr. Miranda. Do you have anything else for me?
No, thank you for your time. Thank you, Mr. Nikki.
Thank you. Judge, one thing, Judge, real quick. I am going to be out of pocket May 5th. I'm starting a 2-week jury trial.
No, we're not going that far. 3
Oh,
weeks
okay.
is the 16th of April, and we are not going to be here 16th of April. So you're probably looking at the 23rd or the 30th.
That's perfect. That'd be fine, Judge.
All right. Beautiful.
Thank you. You have a wonderful
Let
day.
us know if you don't need us anymore.
Yes,
We would
ma'am.
love to do that. Yes. Thank you, Your Honor.
Take care, guys.
Thank you, Your Honor. Thank you, Carlos.
Thanks, Steve.
So is there anything else for this morning?
No, Judge, that takes care of everything.
Muchas gracias.
Yes, ma'am.